Good morning and welcome to Legal Access, brought to you by the Maguire Law Firm. Today's topic is going to be workers' compensation. If you've been hurt on the job or have a loved one or a friend who has, today is the day to ask your questions. Or if you're an employee or a boss or a manager and you want to know what you should do in case somebody underneath of you has been injured, today is the day that you need to be watching and asking those questions as well. Here on the panel to answer your questions, Maguire Law Firm, well represented is everybody here from the Maguire Law Firm, including Ian Maguire. To your left is Brittany Jones, and also Tiffany Buffkin is here as well.
Hey, Dave.
Yeah, it's workers' comp is something we do and been doing for a long time, and it's always a good topic to talk about. People a lot of times have questions, but we're all here, and so if you have any questions about workers' comp or personal injury or anything in that realm that our firm does, please feel free to give us a call at 843-848-8080. That's 843-848-8080.
Got plenty of time to get you on the air here, so don't be shy. Give us a call. We'd love to answer your questions for you. All right, you're at work, you've been hurt on the job, and it seems as though your employer is trying to take care of you. What's the biggest red flag that you see that you need to, it tells you you need to get an attorney to help you out?
Well, a lot of times we hear people say, my boss said that they would help me and I don't need to, make any official report or file anything officially, and that's not a good idea. Your work should most of the time carry workers' comp insurance, and it's for those exact scenarios when you do get injured at work. So that's why they have that in place.
Yeah, you're not suing your boss. Now, and we're sensitive to the fact that some bosses might not feel that way, even though it is not, and your job is extremely important. But at least give notice of an injury to your supervisor, so you have the ability to go back if the injury worsens and it turns into something.
And in writing is always a good
definitely.
option to give notice
and
in writing.
That could be an email or text, just something where you could demonstrate that they had notice within 90 days. And but it most of the time, Tiffany, right? The bosses, the supervisors, the owners, they're helpful to the injured person. Where we have the issue is with the insurance company, right?
Yeah. And workers' comp really is not supposed to be an adversarial system. And so even, if you have a case and your claim's open and the adjuster is providing you treatment, I think that there's a lot of things that kind of can be deemed a red flag, but it doesn't, from someone who's not familiar with the system, maybe they don't realize.
Right.
We've helped someone before that said, well, I didn't get an attorney because all of my treatment was being provided for, and she had multiple body parts that were injured, and the adjuster was only providing treatment for one body part, and our client thought, well, that's not that big of an issue because I have health insurance. So my health insurance, was paying for the treatment for the second body part, but whenever it came time to settle the case, that's a huge discrepancy in the settlement, because if she only has one body part, she can't claim permanent and total disability. So I think even if you have a case and you feel like the treatment is going reasonable, there's a lot of things within the workers' compensation system that usually you're best suited, even if you have treatment being approved, to at least sit down and talk to an attorney before you ever finalize any type of settlement.
Yeah, the insurance company has lawyers in the background telling them what to do as they go through, and they're doing it every day, both the insurance company and the lawyers. So, without question, at least sit down, as Tiffany said, with an attorney early on and understand what your rights are, because it's sad to us when afterwards somebody comes to us and says, oh, I thought it seemed like everything was going fine and I didn't realize. And insurance companies are looking out,
Right.
as they should, for their interests. I mean, that's what, to a certain amount at least, and you want somebody to at least make sure that you're being protected, and any result is going to be optimized in your favor.
Absolutely. That's a good point too, because I think a lot of people don't necessarily realize they're talking to maybe a nurse case manager or somebody like that, and they don't realize that person is then speaking with their attorney. So you as the injured worker might not hear from an attorney from the insurance company, but rest assured they're there advising them in the background.
And a lot of people might be reluctant to call an attorney because, I mean, look, you guys look so scary. I can see why. But I mean, but the thing to keep in mind is that consultations as far as workers' compensation, absolutely free. So pick up the phone and call somebody.
Yep.
Yeah.
Absolutely.
Agree.
Yeah.
So if you have any questions, I mean, as far as, and if you have any questions right now, obviously the number's on your screen. Give us a call. We'll be happy to answer those for you as well. As far as businesses are concerned or employers are concerned, how big do you have to get before you have to get it? Must have workers' compensation insurance by law?
So in South Carolina, if you have 4 or more regularly employed employees, then you need to get workers' compensation insurance. And if you have less than 4, you still can opt to have coverage. And I would advise people to look into that, especially if you are, you know, in a contracting job or some type of employment where it's likely that your employees may become injured. So you certainly can opt to have insurance, even if you're the only person working for your company.
And what are the advantages of doing that? People say, well, if I don't have to, why would I do it? Well, you can get sued, right? Like
Yeah.
outside of comp.
Yes, yeah. Yeah, and then even with workers' comp, if you are subject to the act and you don't have coverage, then there is the South Carolina Uninsured Fund will step in and provide treatment, but the employer is going to face penalties for not complying with the statute and having coverage. But as exactly what Ian said, if you have coverage, then even if you do something that's negligent, that injures one of your employees, the South Carolina workers' comp would be the exclusive remedy. So you wouldn't, you know, find yourself in a lawsuit where you have to pay pain and suffering and loss of enjoyment of life. So there are benefits to both the employer and the employee.
You mentioned negligence here, but in workers' comp, I mean, that negligence is a big part of personal injury, but as far as workers' compensation is concerned, negligence doesn't necessarily have to come into play.
No, and sometimes that's frustrating. And I would say in the vast majority of cases, you know, it's beneficial that we don't have to prove that anyone was negligent, because a lot of workers' comp cases, you know, arise from acts that no one was negligent, no one, you know, intentionally injured you, like you're picking up boxes, or you might trip going down the hallway and sustain injuries. So usually it's, you know, it's a good thing that you don't have to prove negligence, but sometimes it certainly can be frustrating if your employer was the one who was negligent and caused your injury, because unless you can point, you know, unless there's a third person outside of your employer who is negligent, you're not going to be able to file a lawsuit as a result of your injuries.
Again, workers' compensation is our topic here today on Legal Access. If you have any questions, give us a call. The number's on your screen. Or if you want to read it for yourself, there's a book available for you. It's called Mistakes That Can Destroy Your Workers' Compensation Case. It's available at the Maguire Law Firm offices, which is at 1600 North Oak Street in Myrtle Beach. Stop on by and get it. Or you can actually go online as well to maguirelawfirm.com. You can download it for free there too. So we want you to make sure that you're all taken care of as far as your questions are concerned about workers' compensation. Give us a call. We'll get you on the air, and we'll talk to you right after this break. It's Legal Access, brought to you by the Maguire Law Firm. Workers' compensation, that's our topic here today on Legal Access, brought to you by the Maguire Law Firm. Here on the panel to answer your questions, all from the Maguire Law Firm, is Ian Maguire, also Brittany Jones and Tiffany Buffkin, so we're well equipped to answer all of your questions. Workers' compensation, get them answered here today. Call us right now, 848-8080, that is our phone number. If you happen to be on the job, on the clock right now, and you're driving from job to job, get into an accident, it's the other guy's fault, how does that complicate your workers' compensation case?
Yeah, so that is a scenario where you know, the auto accident, you could have a separate case. You'd have your workers' compensation case because you were on the job driving, and then you would also have what we call a third-party liability case for the auto accident itself. So, and if you are in that situation, you absolutely want to make sure that you do go speak with an attorney who does both workers' comp and personal injury, because there are ways that you can really mess yourself up in that situation. You have to handle the workers' comp first, you know, before getting into the personal injury side of it, although those things do go hand in hand. So, you know, we see those things come up often and are able to work both sides of it at our office. I know there are other people that do it as well, but yeah, that's kind of a unique scenario, but we do see come up fairly often.
Yeah, and you use the word complicate, and it's fair word, but it's actually the complication, as long as it's handled properly, it's advantageous to the injured person. If you got to be injured and you're working, and you also have a third party case, it sort of covers the full gamut of potential damages that you might be entitled to, where if it was just the umbrella workers' comp, you're limited in your recovery. There's certain damages that are not going to be allowed under the statute. So yes, it's complicated in the sense that if you don't do it right, you might waive your rights to certain benefits that you may be entitled to, but it's certainly, as Brittany said, a time where you want to sit down with an attorney that's knowledgeable in the field of both personal injury and workers' compensation.
If you're like a lot of people today and you've got a full-time job, but then you do other things like maybe drive for one of the ride share programs, or you deliver food, or you've got another part-time job, if you get hurt on your full-time job and you're going to be losing income from your part-time jobs or your gig work, do you get compensated for any of that?
Yes, under workers' compensation, if you're written out of work and you can't work, then you're entitled to 2/3 of your average weekly wage, which includes employment, the wages for all of your employment, the concurrent employment that you had at the time of the injury. But that's, one of the scenarios where we say it's advantageous to speak with an attorney, is because if you're handling a workers' compensation claim alone, the adjuster for your workers' compensation claim is not going to go out of their way most of the time.
I don't know of time when they have.
No.
But, if you don't point it out to them, they're not going to go going, oh, I know there's a second job and we need to, aggregate the amount.
More,
So exactly.
Yeah. And interestingly, if you have a workers' comp claim at your part-time job, the same standard applies, where you can include your wages from your full-time job. And I've spoken to people before that kind of felt like that wasn't that big of a deal because they weren't out of work and they didn't miss any time. But even if you're not missing time from work, it makes a huge difference whenever the case is settling to make sure that all of your wages are included. Because workers' compensation claims, a lot of the settlement value is based off of what your average weekly wage was before the accident.
Yeah, it's like you said, it could be a gigantic difference if you don't include your full-time job, and it doesn't hurt the full-time employer at all. It's just recognizing that that's what your average weekly wage is when you combine the two jobs.
Speaking of making a difference, one thing that would make a difference would be future medical costs. How are those determined by whoever makes that decision as for how much money you're going to need for future costs?
So that really depends on the facts of the case. If someone is a Medicare recipient or they're going to be on Medicare in the future, then they're not going to be able to settle out their future medical expenses without submitting to CMS for them to review and say that this is a sufficient amount of money to put to the side under a Medicare set-aside to protect Medicare's interest. If someone is not a Medicare beneficiary, then if you go to a hearing, the commissioner cannot and will not close out your medicals and give you money, so your medicals would just remain open. So, with future medical cost and workers' compensation, if you're at a situation where you want to clincher the claim, which is a full and final settlement, and it includes future cost, then, there are tools that you can utilize to try to estimate what the future cost might be. Sometimes that's like an actual company that you pay to put together a cost projection, or you can just kind of estimate based off of the tools and past treatment and what the fee schedule is in workers' comp.
Yeah. What's nice about comp, though, as Tiffany said, you can leave your meds open, whether it's advantageous or not is a case by case. Whereas if you were in a car accident or you were hurt outside, nothing to do with workers' comp, and you had a case, you're really getting one bite at the apple. So in those cases, we'll hire an expert that will project what the future cost is going to be, and then you're asking a jury to consider all of that, because you can't go back and you can't leave leave meds
Right.
open. So it's different. Yeah.
How long will workers' compensation payments continue after an incident?
Well,
Yeah, so if
It's
somebody's,
generally-
it depends again. If somebody's written out of work, then those will continue until the doctors have placed them at maximum medical improvement, which just means they've reached a plateau in treatment. Depending on how long it takes that person to get to maximum medical improvement, there may have to be a hearing before the weekly checks can terminate.
Right.
and technically there's
Yeah.
a 500-week
Yes.
cap, but like everything, there's exceptions,
Yeah.
and there's exception to that if it's a paralysis situation or a brain injury, then the 500 weeks may not apply. So it's, again, very important to talk to an attorney
Yeah.
early on in regard to
Yeah.
those issues.
If a doctor says you're at MMI, maximum medical improvement, but you don't feel as though you are and you really can't go back to work, how is that dispute mitigated?
You can get an independent medical exam, we call it an IME, where you go to your own doctor and have them look and see if they agree or not, or if you do need additional treatment, that is an option.
And then depending on the state, some states, the second opinion, you're entitled to a second opinion under
Yep.
under the Workers' Compensation Act. In South Carolina, you're not technically entitled to a second opinion, but generally, if you have legitimate injuries and concerns, then most commissioners will grant a second opinion if you request it.
And that's a great point, that each state has their own statute and rules regarding workers' comp. North Carolina, South Carolina, we do work in both states. They're contiguous, but yet there's differences in certain aspects. For instance, North Carolina may not allow you to combine the two jobs,
Yeah.
right, where South Carolina does. So there's little things that are different.
Yeah.
As far as doctors' reports go, I mean, if they say maybe you're not ready for full-time work, but you're okay for light duty, what if your job doesn't have quote-unquote light duty work for you?
Yeah, so in that scenario, as long as you're still employed with the employer, or I'll rephrase that, because technically whether you've been terminated or not, you can still be entitled to benefits. But as long as you were not terminated for cause, then once the doctor puts you on light duty restrictions, the employer has two options. One is to accommodate your restrictions, and then the second option is to just pay you your weekly compensation rate until you've been released to full duty. And there's an exception where if you were working after the accident and the employer terminated you for cause, then they're not really entitled to give you light duty or TTD benefit, the weekly checks, while you're written on light duty work.
All right, we got our final segment coming up in just a second, so last chance for you to get your phone calls in, 843-848-8080, workers' compensation. That's our topic today. We'd love to talk to you right after this break, right here on Legal Access, brought to you by the Maguire Law Firm. Workers' compensation, that's our topic here today on Legal Access, brought to you by the Maguire Law Firm. Here on the panel to answer your questions. We still got about a little less than 10 minutes if you want to get a last-minute call in. Ian Maguire, also Brittany Jones, Tiffany Buffkin, all from the Maguire Law Firm. So call us today. We'll get those questions answered. Let's ask a couple of, I don't want to say off-center questions, but working from home or remote working has been much more popular since the pandemic a couple years ago. How can you prove if you've been hurt at home while you're supposedly on remote working that the injury that you sustained was something associated with your job?
Yeah, I mean, I don't think that the proof is much different than normal. If you don't have a witness there, it doesn't mean you don't have a claim. It's just, there's the credibility of the person making the complaint or of the injury and the accident can be, I guess you can cross-examine that if you're a defense attorney, but I think it's important, even more important in a case like that, to give notice quickly. You usually have 90 days to give notice. I would think it'd make your life easier if the second it happened, you called your supervisor and said what happened, and if they want to send you to a doctor right away, then you can go. And but you know, if the decision is made to allow work at home, then I don't think the burden of proving the case is any different. It's still, you know, you give notice within the time period, and it should be liberally construed in favor of the injured person making the complaint, and that's what the statute, you know, and the case law says. So.
How about repetitive trauma, whether it's carpal tunnel, whether you're lifting heavy boxes over and over again? What special circumstances do you have to go through to be able to prove that your job was responsible for this person's injury?
Yeah, so with repetitive trauma cases, it's, you know, the same as an injury by accident, except for sometimes you know, the notice is different because you might not realize as soon as you fill a complaint that it is from a repetitive trauma injury. So you have to give notice once you've reasonably, you know, deduce that that your injury is related with the repetitiveness of your work, then you would give notice for that. And then in repetitive trauma cases, really prior medical complaints will come up, but you'll still need a doctor to say to a reasonable degree of certainty that the injury that you were experiencing was related to the repetitive nature. So I do think it's important whenever you are reporting to the doctor that you make an accurate timeline of, you know, if you're having issues, go see a doctor, outline, you know, the work that you've done and kind of the progression of the symptoms and pain to your doctor. I think that probably where repetitive trauma claims become harder than an injury by accident is in situations where you notice that you're having issues and you think, oh, it'll get better, so you don't go get treatment,
right,
you know, for a year into your job. That's where I think that they become more complicated. But if you've reported it to your doctor and, you know, once you realize that it is related to your work, then you need to report it to your work. That you're having this issue and that it's job related.
You know, I think it was back in 2007 they made the requirements for proving that case a little more stringent. But from a practical standpoint, if a case is questioned by the insurance company, we're getting a doctor to say to a reasonable degree of medical certainty that's related, that it aggravated a condition or it caused a condition, right? So. Yeah. You know, I think Tiffany's right. It's a lot of times it's a timing thing that makes it difficult. But from a proving from a medical standpoint, it's probably not much different for the lawyer the way we're going to demonstrate that the injury is related.
Tell you what, we're just about out of time on our show here today. When we get back together next week here on Legal Access, we're going to be talking about personal injury. So we'll be talking about a lot of these same type of things. But if you have any personal injury questions, hang on to those until next week and we'll get those answered. Remember, if you have any more questions about workers' compensation, you can get your free book at the Maguire Law Firm office. It's located at 1600 North Oak Street in Myrtle Beach, or go online to maguirelawfirm.com. For Ian McGuire, Brittany Jones, Tiffany Buffkin, I'm Dave Priest. See you again next Thursday.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are